Thank you all for joining us. Today you'll be hearing from myself. I'm Anthony Kuhn. I'm the managing partner for the Buffalo office for Tully Rinckey. I'm the chair of our firm's national security practice group and military law practice groups. I am a 27-year veteran of the Army and Army Reserve, and that's the main reason why I practice in this area. But probably about half of the work that I do here at the firm involves security clearance cases. And you'll be hearing from my colleague today, Ryan Nerney. He's joining me from the Ladera Ranch office where he's the managing partner. Ryan has litigated, I don't know, Ryan, correct me if I'm wrong, but probably 1,000 cases by now or more. So Ryan's very experienced in the national security realm, and we work together closely. He's in California and I'm in New York, but as you can see, we've got some pretty good technology here at the firm, so we're able to communicate daily and work on cases together. So anytime we get a chance to jump in together and do a webinar like this, it's great. It's a panel discussion. We'll go through a few different topics today, but first I just want to touch on our disclaimer. Nothing here that you hear today should be taken as legal advice. We're not here talking about a specific case. I have already seen a few names on the screen here, so for people that I know personally and have worked with in the past. This shouldn't be taken as legal advice directly related to your case or any other case. This is just going to be a general discussion that Ryan and I will have about some of the different adjudicative guidelines, and that'll be it. So if you have any questions about your case specifically, feel free to give us a call. We'll be happy to chat with you about those cases. So just briefly, some of the topics we're going to go through today. We're going to go through a few of the guidelines, but the main theme here today, the main thing we're going to be talking about is some of the most common types of guideline violations, the things that we see the most often, the things that tend to result in people getting their security clearance applications either denied or having their security clearances revoked. So we'll talk through some of those guidelines. We'll break it up a little bit. I'll talk about B and C, which is foreign preference and foreign influence. Ryan's going to talk about guideline F, which is financial considerations. Then I'll jump in and talk a little bit about guideline H, which deals with drug involvement. And then many of you have heard or seen on the news the recent case involving a National Guardsman who released some classified information over a video game. So Ryan's going to touch on that. And then we'll circle back and go over, we received many questions today, which is great. There's some really good questions in there. So we compiled a handful of them at the end of the webinar here today. We'll go through right down the line and try to answer some of those questions if we don't already answer them through the discussion here today. So we'll start with guideline B. You saw on the invite, you might have noticed that we kind of had guideline B and C lumped together because the two of them often get confused, and the thing that triggers guideline B might also trigger guideline C. It's very common to see a statement of reasons that lists guideline B and then also guideline C, but it's usually just the same allegation relisted for both guidelines. They're very similar, but there is a lot of confusion around the two of them because of that. So I'll try to drill down and explain the difference between the two. And we've had some pretty significant cases involving guideline B and C. At least one of them I know is published. A lot of the cases for security clearance will get published. They just won't have the applicant's name in there, but they'll have my name in there. They'll have Ryan's name in there. So I know I've litigated recently a guideline B and C case involving a military officer from the UK who was retired from the UK, had a clearance in the UK, obviously, still had some high-ranking military friends and acquaintances in the UK, purchased land in a third country, and then settled in the United States with his family and was trying to get a security clearance to work a project that he was working here in the United States. So I litigated that case from start to finish, and including Department Counsel appealed the case, and I litigated the case on appeal and won again as well. So pretty familiar with these guidelines. I did a lot of work in them, and that one took took a lot of work to put everything together. And as you can imagine, given the potential government concerns there, but we're able to mitigate the concern, and we'll talk through how. So for foreign influence, the main thing you're thinking about here is the potential for somebody to influence an applicant or somebody who holds a security clearance. So is there some foreign business, a foreign contact, a foreign national? Is there somebody out there that the applicant has close or continuing contact with, that individual is also bound to in some way. So affection, business, common interest, things of that nature. It could be anything. If you look at the SF-86, when you're filling out the SF-86, there is a foreign contacts question there, and the question is often misunderstood. People will say, well, you know, they get hung up. I don't know what close or continuing is, and they get hung up on that part of the question, and they don't read the second part of the question. The question is close or continuing contact with someone with whom you're bound, and then it gives a bunch of different examples, and it's not a complete list, but it gives you an idea. So you have to have both of those for most agencies. You don't want to over-report and give every name of everybody that you spoke with when you were on vacation. You don't have to give the name of the classmate you had 5 years ago that you went to lunch with once, because that's not close or continuing contact, and you're not bound to that individual in any way. So some agencies, like CIA, for example, can be a little tougher on this, and they want you to list everything. You know, if you have a Facebook friend that was a translator when you were in Iraq or something like that, that's a foreign contact. That's somebody you have to list. So, you know, some agencies require a little bit more, but most agencies want closer continuing contact with someone with whom there's some type of bond. So that's the concern, and that's the question that you'll see, and it is a two-part test, so keep that in mind when you're considering whether or not to report an individual. When you look down at mitigation, and this is all information that you can get online. Many of you have reviewed the adjudicative guidelines before, but it's pretty easy. You can Google the adjudicative guidelines and review them yourself. But let's say, for example, you have to disclose an undocumented parent, or you know, ties to a foreign national who may not be in this country. They may just be somebody that you communicate often with. Maybe it's a family member in another country. So you have to disclose them, but there's forms of mitigation for that disclosure, or to mitigate that disclosure. And as I said, you know, the government is concerned with whether that individual can influence you in some way. Positive, negative, doesn't really matter. Meaning, do you like them so much that they can help persuade you to give them information because you have such a good relationship with them? Or did you have a one-night stand with a foreign national who now is using that information to pressure you or coerce you to give them classified information? So either way, they're influencing you, and both of those situations might fall under Guideline B. So to mitigate that, you would argue things like that foreign national isn't tied to the government in any way. They're not a risk. They're not a government employee or an agent of the government. It's just somebody that you met while you were going to college or something like that. The contact is casual and infrequent. And like I said earlier, they're looking for close or continuing. Casual and infrequent is not close or continuing contact. So some people will over-report. The way that you can mitigate that is, you know, say that you get a statement of reasons and there's an allegation that you're a risk because you are friends with fill in the blank. The way that you can respond to that and mitigate that concern is by showing that that contact is casual and infrequent. It's my cousin, you know, I only know that individual because of my family, and we exchange Christmas cards. That's it. That's casual, that's infrequent. Sure, they know about them, they know that you have that foreign contact, but it's not close or continuing contact, it's casual and infrequent contact. You would, if an individual that you have as a foreign contact or list as a foreign contact, if they are somebody you met on official government business, then you would list that. And don't just say, well, I met him because I worked here, but give them good information, give them verifiable information, because nobody's going to take your word for it in the adjudicative process. So make sure that you're giving them some type of evidence to show that the only reason you made that, you got to know that individual, the only reason you have that foreign contact is because you were somewhere or doing something on official government business. Make sure that you report it. If the government comes to you and alleges that you're a Guideline B risk, you should be able to say to them, well, I reported this individual, and you'll talk through the other forms of mitigation as well. But if you didn't report them, there's a good chance you'll be looking at a Guideline E violation for intentionally omitting information. That's the personal conduct guideline. So you want to make sure that you're reporting anybody that you think you have a close or continuing contact with, that you're bound to in some way. And then finally, just think of it as a balancing test. They want to know if it's somebody who has minimal effect on you, or if it's such a sufficient contact or relationship that they could tip the other way and they could maybe influence you in some way. So that's what they're looking for. Is it somebody that, and I'll talk about in a minute, the way that you would handle a conflict of interest, or what they're looking for as far as a conflict of interest. But this feeds into it. Is your relationship with this individual so good, so strong, that the United States would expect you to resolve a conflict of interest in favor of another country because of this individual? Or would you resolve that conflict of interest in favor of the United States because your ties to the United States are so strong? Maybe you're military, maybe you've worked for the government for a long time, all your family's here. So it's kind of a balancing test. Which way would you go if a conflict of interest ever came up? That's kind of the way that you look at it, and the argument that you would make to beat a Guideline C violation. So we'll jump to Guideline C. So first one was foreign influence. Second one is foreign preference. The biggest difference here is the preference is the preference of the applicant. So we were looking before at whether someone can influence the applicant. Now we're looking at what does the applicant prefer. Does the applicant prefer another country over the United States? And this is really where that conflict of interest question comes in. Do you have such a strong relationship with foreign nationals, a foreign government? Are you so heavily invested in another country that you might resolve a conflict of interest in favor of that other country? If so, then the United States can be very reluctant to give you a security clearance. And there are a bunch of different things that are looked at here. I took some notes here because I don't want to plug them all in here on the PowerPoint, but this is where you see things like dual citizenship. A lot of people that apply for security clearances, they're dual citizens, and this has changed over the past few years. Not so long ago, they used to want to see everybody renounce citizenship. Now it's not always necessary to renounce citizenship, but have you expressed a willingness to renounce citizenship? If you don't care about the citizenship, if it's just citizenship you got because your parents are citizens of another country, or you were born in another country but your life is here and you don't really care about the dual citizenship, then you should renounce the citizenship in the other country, because it's the best way to respond to being a dual citizen if you're trying to get a security clearance. Renounce citizenship of the other country. If for some reason you want to keep citizenship in the other country, just make sure that you can explain the reason for that. If it's because you intend to retire in that other country, or you own a bunch of property in that other country, you've got a bunch of bank accounts in that other country, and being a citizen makes it easier for you to travel back and forth and do those things. If that's the case, then you're going to want to be careful about the way that you disclose that information or answer questions around that information, because it starts to look like you have a preference for the other country over the United States. So other ones that come up, a foreign passport, and I know Ryan and I have dealt with this quite a few times because adjudicators don't even always apply this rule correctly. If you have a foreign passport, just having one in and of itself, it's not great that you've got a foreign passport, right? But you can have a foreign passport and a security clearance. You just shouldn't be traveling into the United States on a foreign passport. That's where you're going to get yourself into some trouble. If you're traveling into the United States using a passport from another country, then you're showing a preference for the other country. As simple as that sounds, that's what they're going to, that's a conclusion they're going to draw. You are showing a preference for another country by traveling into the United States using a passport from another country. If you have a United States passport, use your United States passport when you're traveling, especially when you're traveling into the United States, which is really what it hinges on. Military service and willingness to bear arms for another country is taken into account here. So if you, in the example I gave earlier, if you were an officer in the military in the UK and you came here to the United States, that is going to be an issue that you're going to have to mitigate. If you are somebody who says, I'm going to go take up arms for the Ukraine, then you are putting yourself in a position where you might get a statement of reasons and you might have to litigate to keep your security clearance. So if you want to keep a security clearance, don't go join a foreign militia or military and take up arms for another country, because you're showing a preference for that other country if you do that. Receiving benefits from a foreign country, like a retirement pension or something like that. That happens quite often. People retire and they'll come here to the United States, If that is the case, then the easiest way to mitigate that is just showing where that money is going. If you're investing that money here in the United States, then it's going to be easier for you to get your clearance and mitigate that concern. If you're receiving money in another country and it's in a bank account in another country, it's going to be very difficult for you to explain that, because you shouldn't have bank accounts in another country if you want a security clearance in the United States. So using that foreign citizen, which brings me to the next point, which is using the foreign citizenship to hide money or to make more money maybe in another country. That's going to be another issue that you'd have to overcome when you look at Guideline C. And then we see some things like seeking political office. I know I've worked cases in the past where individuals were accused of voting in Russia. If you vote in a foreign country's election, then you're showing a preference for that country, and you're putting yourself in a very difficult position, because it's going to be tough to overcome a Guideline C violation if you're voting in Russia. And then also you look at whether these things that you have to report, did they happen before your clearance was issued, and did they happen before you became a United States citizen? If they happen before one or both of those things, then it won't be as big of a concern. But if it happened after you got your clearance, let's say you get a security clearance and then you go and you file for citizenship in another country, that's going to be a problem. That's going to be a difficult one to mitigate. So again, we get back to that balancing test, and can you resolve a conflict of interest in favor of the United States, or would you resolve that conflict of interest in favor of another country? And then this is just a brief roll-up on Guideline B and C. So we talked, just as a reminder, for Guideline B, can you be influenced by a foreign national? And Guideline C, would you prefer another country over the United States if there were ever some type of conflict of interest? Ryan, I'm sure you've got plenty to add there if you want to jump in.
Yeah, just a few things I can add, Tony. Obviously you mentioned the balancing tests for both Guideline B and C. Just for your reference, essentially what that does is that it's trying to measure that if whether it's the foreign preference or foreign contacts or what have you, is a heightened risk to the national security of the United States. So that's essentially what those balancing tests are trying to measure. Also, another thing that I see, you heard Tony mention that a concern potentially could be family members in a foreign country. But it's important to note that just having a family member in a foreign country is not in and of itself disqualifying for a security clearance. It's more aspects like Tony was talking about, the amount of communication, the type of communication, things like that. So just having a family member in another country is not by itself disqualifying. There's other factors that go into it that adjudicating officials look at. I think that's all I had for Guideline B or C. Just a shameless plug I have. You heard Tony and I are both executive board members for the National Security Lawyers Association. We do a podcast for that as well. And coincidentally, I just did one on Guideline B and C that should be published fairly soon. So it'll cover a little bit more of that topic as well, kind of overlapping what Tony kind of went over today.
All right, thank you, Ryan. And I did just have one thing come to mind as well. I know I've done. You reminded me with the podcast. I did a podcast not too long ago for another security clearance agency, and we discussed the Guidelines B and C and the potential for a Guideline B or C violation for someone who, and the example that was given was someone has a one-night stand with a foreign national, someone from Russia, and is that reportable? Well, probably, but not always. You have to have the close continuing contact. You have to have that bond, right? Or you have some type of exchange with a foreign national that could potentially open you up to coercion. If you're married, then it is absolutely reportable, because you have put yourself in a position where you're now open to coercion, or blackmail or something, where that individual could come back to you and try to get classified information, which you would have to report if the individual asked you for that type of information anyway. But just putting yourself in that situation and being in a situation where you've now opened yourself up to coercion, that is the part that makes it reportable. So that's where we'll kind of hinge on. But I don't know why that question comes up. as often as it does. But I've dealt with it a few times. So, all right, we're gonna jump ahead here. We'll Ryan, if you want to go ahead and take the lead here on guideline F.
Yeah, sure. So, guideline F, as Tony mentioned at the outset of the webinar today, is financial considerations. That doesn't always necessarily mean, debt or failure to pay taxes, things like that. There's other aspects that go into it, which I'll get into in a minute. But essentially, it's just looking at your, I want to call it your financial standing, but that's the word I'm going to use. And if that financial standing can be used to get you to coerce you into divulging national security secrets, things like that. A common theme is that, if you have a significant amount of debt, that leaves you open to some sort of coercion because a foreign, national who's trying to obtain national security secrets can come to you and say, hey, I know you have all this debt. I'll pay it off for you. Give me some secrets. At least that's the government's concern, or the main concern. And, going a little bit more into some specifics, failure to live within one's means, satisfy debt, you can't meet your financial obligations. It not only opens you up to that coercion that I was talking about, but it also goes to some of the aspects that they look at with the whole person concept, which is, poor self-control, a lack of judgment, unwillingness to abide by rules and procedures, things like that. So all of those things can be disqualifying when it comes to guideline F. A lot of times we see the most common thing we see for guideline F is debts. And a lot of times I get questions of, oh, I have debts, I have student loans, is that going to be an issue? It comes down to the status of that debt. So if you just have debt and you're timely paying on that debt, they're not going to care. It's not going to be a big deal, because if you're timely paying it, you're, following all the rules, you're meeting your financial obligations, not a big deal. Where it comes into an issue is that if that debt is delinquent, right? So the delinquent debt is, again, kind of something that goes into opening you up to that coercion that I was talking about earlier. Financially overextending yourself does kind of make you, at least in the government's eyes, susceptible to that type of behavior. So those are kind of the concerns that the government has with the financial considerations. But obviously the good news is that, with the disqualifying conditions, there's also mitigating conditions that come with that as well. So one of the things that you commonly see is, what did you do, right? Did you act responsibly given the circumstances? One of the things, as Tony mentioned, I've been doing this for a while and I've done a significant number of these cases. And one of the things that is not really mentioned in the mitigating conditions, but that judges and adjudicating officials take into account, is not just the responsible aspect of the mitigating condition, but if you acted reasonably as well, right? So one of the things that they look at is, okay, did you resolve this debt, right? Your delinquent debt for, I don't know, you got a car repossessed and now you owe, $10,000 on that debt, right? Where it comes in the reasonable aspect is what you did to handle that debt, right? So that's the reasonable and responsible aspect of that mitigating condition. So if you have known about this debt for 5 years, let's say, for example, and then you don't do anything about it until you get that statement of reasons, or until, the security clearance situation comes in, what that tells a judge most of the time is that you did not act responsibly or reasonably under those circumstances, because what you did was you waited 5 years until it became an issue, and then you took care of it. Now, sometimes that can be mitigating, but a lot of times judges take that into account. That kind of goes into what Tony has here for number 5 as well, is, there's no judgment and it'll drop off my credit report. A lot of times, people come and ask us, hey, this debt dropped off my credit report. I don't have an obligation to the creditor anymore, so it shouldn't be an issue, right? Well, not necessarily, because just letting it drop off your credit report is not acting reasonably responsibly under the circumstances, because what they want to see is that you're making some sort of effort to try and resolve the debt. And if you just let it fall off your credit report just because it's been so long, that's not really an effort that they're looking for. So that's not really mitigating in and of itself. So, but again, the primary aspect is delinquent debt. If you just have debt, as long as it's not, debt that was obtained under illegal means, then that's something that they're not really going to care about. It's only the delinquent debt, and if you're taking, the proper steps to try and resolve that debt. Another thing that I have seen, and I know Tony's seen this as well, kind of pop up more recently, is the tax issue. And that kind of is twofold. Sometimes it's failure to pay their taxes, and sometimes it's failure to file their taxes, and sometimes it's both. There's unique circumstances that sometimes can roll into that, but essentially the failure to pay and or file your taxes, it really comes down to, you not following the rules, especially federal law, to be perfectly honest, of filing your taxes and paying your taxes. So if there's, 1 year, if you miss it, depending on the circumstances, may not be a big deal. But if you show, as Tony has here, a pattern of behavior, then that's something that they look at. So how you mitigate that, you want to obviously try and file and pay all of your taxes. And then, if you're able to kind of show a pattern that you're continuing to actually make those payments and to timely file those taxes. Student loan debt, kind of the same thing. I touched on this a little bit, but it's delinquent debt, right? Tony has here predatory lending. That's something that does sometimes go along with student loan debt. There's something called the borrower's defense for repayment that you can potentially file if there's some sort of predatory lending issues with the student loans that you got. But it all goes back to the same thing. If that student loan debt is delinquent, then you need to try and act reasonably, responsibly under the circumstances in order to try and resolve that. Another thing that judges like to look at is that, okay, there's some unique circumstances that may have caused this delinquent debt, but why won't this happen again? They want to see if you're a security threat, essentially. And one way you can kind of show that you're not is, do you have a budget? Are you timely paying other bills? Have you established a pattern of payments, for everything else? It's taking certain steps to try and ensure that any delinquency or any issues, even unexpected issues, can be handled fairly quickly. And one of the ways that you can show a judge that you're doing that is having a budget. Gambling scams, this one's kind of unique. We don't necessarily see gambling issues all the time, but this kind of goes into the same thing as far as making yourself susceptible, as well as going into some illegal activity. If you're, trying to conceal gambling losses from your family or friends, that potentially can cause some conflict. Or if you are, indebted to some loan sharks or something along those lines, that's going to increase the amount of susceptibility to coercion and duress and things like that adjudicators look at. So, just gambling in and of itself, you go to Vegas for a weekend and you gamble, you lose $500, not going to be a big deal. But if it's a consistent pattern that develops into a problem, that's something that's going to raise a red flag. The last thing on here, as far as financial consideration goes, that sometimes is a concern, is bankruptcy. Now, obviously, unique circumstances can happen. You lose your job, you get laid off. There's, sometimes you get demoted for one reason or another. Whatever it is that causes you to, have that unique circumstance. You're going through a divorce, or some family problems, something like that, an unexpected medical procedure. Any of those, those are just obviously some examples, but any of those things are unique circumstances that potentially could lead to not only the delinquent debt, but eventually could lead to bankruptcy as well. The one thing that they look at is if there's a pattern, right? So if you file bankruptcy once and there's those unique circumstances, they still may raise a red flag, but you should have some mitigation there. But if it's, you filed bankruptcy in 2012 and you filed again in 2015 and then, filed again after that, that shows a pattern. And that is, as I mentioned at the very outset, that you're not living within your means. So that's something that kind of goes hand in hand with that bankruptcy, if it's kind of a consistent pattern. One thing that I look at that sometimes judges look at as well is also the type of bankruptcy. If you have Chapter 7, that's basically discharging all of your debt that's able to be discharged. If you do Chapter 13, then that's kind of what I could consider kind of like a glorified payment plan. So you're making a monthly payment to an actual trustee in order to resolve those debts. So if you have the ability and you have the option, it's better to file the Chapter 13. Obviously, that's not always feasible, and it's not, the end all be all if you do file a bankruptcy, if it's Chapter 7. But those are some things that you look at. But, primarily, like I said at the very beginning, they're really looking at any type of financial behavior that could potentially raise the risk for any type of coercion or influence or something like that. So, if you're taking steps in order to resolve those debts, in order to make sure your taxes are timely filed, things along those lines, then they shouldn't really have, you should be able to, mitigate some of those concerns. The last thing I'll mention is, as far as a mitigating aspect, is disputes. So sometimes you have identity theft, sometimes you have circumstances or issues, that kind of, lead, again, kind of going to predatory lending, or, a lot of times, like I said, it's identity theft, and, you just don't owe the debt. There is a mitigating condition where you can dispute that debt, but there has to be some sort of proof. So you can't just say, no, I don't agree, that's it, I don't owe it. You have to take some sort of step, like in all the other mitigating conditions, in order to show that, the dispute not only happened, but also was successful. So those are kind of the main aspects for the disqualifying and mitigating conditions for Guideline F. And I'm sure Tony probably has some other things to add there as well.
Yeah, just a little bit. So just to be clear, the question we get a lot is, will bankruptcy cause me to lose my security clearance? And, the answer is, well, it depends. And Ryan explained a lot of that answer, but is it the responsible thing to do given the circumstances? If you fall behind on debt and you just let that debt keep going, and it gets worse and worse, it snowballs, you lose your house, you lose your car, you have no chance of catching up. And then you lose your security clearance, and you get notified of a statement of reasons because CE caught you, and now you've got to answer some questions. Then you're probably going to lose your security clearance. But had you done the responsible thing maybe a year or two prior and filed for bankruptcy protection, you could have kept your security clearance. So keep that in mind moving forward. Don't think that just filing for bankruptcy protection is going to cause you to lose your security clearance, because Ryan mentioned earlier the whole person concept. That's really what it's going to come down to. It's, can you mitigate this specific allegation, this Guideline F allegation, and then what's the whole person concept look like? It's not going to be a decision that's made in a vacuum. So there's very few things that are dispositive in security clearance adjudication. If you got convicted of a felony yesterday, you're probably not going to get a security clearance today. I can't think of too many other examples, but there aren't a lot of things that are dispositive in security clearance litigation. But as far as Guideline F is concerned, are you, as Ryan mentioned multiple times, are you living within your means? And if you get into trouble, are you doing the responsible thing given the circumstances? And then the only other thing that I'd like to expand a little bit on is the gambling and the scams. As Ryan said, they're not always bad. I have family members who enjoy going to the casino, just like I enjoy going on vacations and doing things with my kids that cost money. So if it's something that you enjoy doing and you have a budget for that thing, and you're not living outside of your means or getting yourself into trouble by doing it, like gambling, and Ryan and I have made this argument, I'm sure, dozens of times. Just because my client gambled or the applicant gambled doesn't mean they shouldn't hold a security clearance or that there's some kind of risk. It's just something that they enjoy doing. It's something that some people enjoy passing their time by doing, and they budgeted for it. So if I make a certain amount of money each week and I spend, my portion that I budgeted for at the casino and no more, and I didn't have to continuously go through counseling programs and, lie to my family like Ryan mentioned earlier, things like that, then you should be fine. So going to the casino is not going to cause you to lose your security clearance. Just like certain circumstances where people give a lot of money to their, I don't call them spiritual advisors, you know, some people might think that that individual is being scammed, and I've litigated cases like this in the past where it's not my religion, it's not something I would do, give tens of thousands of dollars to, you know, somebody online who's my religious advisor or something like that, right? The government's going to call that a scam. You still might be able to keep your security clearance, even if they allege that you're being scammed and that you gave too much money to the scammer, which you would say is your spiritual advisor. I'm giving this example because I've litigated this exact case, and that individual also had to file for bankruptcy protection because he gave so much money to the individual that he perceived to be his spiritual advisor, which is his choice, not mine. He gave so much money that it caused him to have to file for bankruptcy protection, and we were able to litigate that case, and he was able to reestablish his security clearance and get his job back because of the religious argument that was involved. You know, if you revoke his clearance for giving too much money to his church, then you got to revoke everybody else's clearance every time they put money in the tray that gets passed around at church because they're all getting scammed. You know, they can't make that argument. They can't force their ideology on you. So, you know, if you ever find yourself in a situation where you have given money and you're being told that you shouldn't be giving money to those organizations, well, then your argument is, I'm living within my means, I'm paying my bills, you know, as long as it's not some type of organization that is recognized as some type of hate group, then you should be fine. And again, you know, it comes back to, did you budget for it, and are you living within your means when you're spending that money? So keep that in mind in the future. Anything else, Ryan, before we jump to the next one? All right. We're going to jump to guideline H. So this is a hot topic. This is, you know, we get more and more calls about this one lately. I think we're now at 38 or more states have legalized marijuana in some sense. There's a lot of other drugs that are related, you know, that we get calls about, obviously, but marijuana is going to be, you know, a problem for a lot of people trying to get security clearances in the near future, because a lot of college students don't think about the fact that they're going to be applying for a security clearance soon, and they're taking their buddy's Adderall to study for an exam, which is illegal. They're going to dispensaries and they're buying and using marijuana, which is illegal. It doesn't matter if the state has legalized marijuana. The reality is at any point the federal government can come in and shut that down still, because the federal government hasn't legalized marijuana. They treat marijuana like cocaine or any other drug. It's a Schedule I drug. The federal government has not moved or budged on that. I think they will in the near future, but that still doesn't mean that people who hold security clearances are going to be allowed to use marijuana, or people who are in the military or own firearms are going to be able to use marijuana. Just because marijuana is decriminalized doesn't mean people can use marijuana and hold a clearance, own a gun, be in the military. We'll see what happens when that legislation gets published. But just like you can't drink alcohol on the job, you know, you probably aren't going to be able to smoke marijuana or have marijuana in your system or THC in your system with certain career fields. So we'll see what that looks like. But for now, it's illegal. The federal government hasn't moved on that. If you use marijuana, you're putting yourself in a position where it's going to be a little tougher to get or maintain a security clearance. And the concern that the government, the argument that they'll make here is that using those drugs can cause you to impair your judgment, or it's a type of impairment that could increase the risk of an individual sharing or leaking classified information. Just like you're not allowed to own a firearm if you use marijuana, because the belief is that it could impair your judgment while you're in the possession of a firearm. So it's the same argument, just, you know, one is a clearance, one is a firearm. But the issue comes down to those drugs are impairing your ability to make a judgment call or do certain things, and the federal government would rather not have people who hold security clearances impaired. So that's the concern. How do you mitigate it? Well, it depends on what drug we're talking about. So if you call me or Ryan today and we start talking and you say, hey, you know, I have some drug concerns, and we say, okay, you know, give me the rundown. Well, I used Adderall. Okay. Were you in college when you did it? Yeah. Okay. Have you used it since you got out of college? No. All right. Probably not too big of a deal. It's, believe it or not, it's fairly common. So, you know, there's certain things that we can get past without having to do too much work. Marijuana, there's going to be a lot of questions about that. They're going to ask about recency and frequency. So when is the first time you used, but when is the last time you used, more importantly, and how frequently did you use marijuana or any other drug? And you'll have to disclose all that on your SF-86. And a lot of times we get the question, well, what if I don't disclose it? Are they going to catch me? You know, and I see Ryan laughing. You know, we get the question a lot. We're not ever gonna advise somebody not to disclose something that you have a duty to disclose. So our response to that question is going to be, well, you have a duty to disclose it. But the reality is, we don't know. They might not ever catch you. You know, I would never say withhold that information because, first of all, you have a duty to disclose it. Second, you're going to get somewhere in your career, hopefully, where you're gonna get a promotion, you're gonna need a higher level clearance. Something's gonna happen where maybe you have to take a polygraph, or that information is gonna surface one way or another, and it could cause you to lose everything that you've worked for to that point. So sometimes, most of the time, it's easier to just disclose the information and try to mitigate the information up front, because if you hold on to that information, now you have lied on your SF-86, your application for a clearance. You've lied to the investigator. You've created a bunch of different situations where you're going to get hit with guideline E violations, those personal conduct violations for intentionally omitting information. And the way that you mitigate a guideline E violation is by making a prompt, good faith effort to disclose that information. Well, you had all these opportunities to make a prompt, good faith effort to disclose the information, and you lied during each of those opportunities. So if that happens, it's going to be far more difficult to mitigate those concerns later than it would be upfront if you had prior drug use. So how long ago was the marijuana use? Well, we have recently been getting very good outcomes with people who have used marijuana as recently as a month before applying for a security clearance. It depends on the agency. Obviously, every agency treats it differently. If it's an agency that they have heightened concerns of drug involvement or trafficking involvement or something like that, then they're gonna be reluctant to push you through. They'll probably catch you on suitability and have a suitability or an employment decision issue. But if you're Department of Agriculture and you used marijuana a month ago for what you believed were medicinal reasons, even though the federal government doesn't recognize that, but maybe you and your doctor did, and you now have a plan, you now are using a different type of treatment that you think is more effective, and you're able to convince the investigator and the adjudicators that you have this better course of treatment, you haven't used marijuana in a month, you really didn't like how it made you feel anyway, and you're never going to do it again, there's a good chance you're going to get your security clearance. So it's just going to, like I said, depend on the recency, the frequency, the purpose of the use. If you used it, like I said, for medicinal purposes, then you've got a better chance of being able to overcome that. Where if you were just getting high last week, that's your response to an investigator or response on an application, it's going to be a little tougher. Not impossible, but a little tougher to mitigate those concerns. If you do these things while holding a security clearance, then you're making it far more difficult to keep your security clearance. You're breaking the law, you're breaking federal law, and you're using drugs while holding a security clearance. So we have mitigated quite a few cases, but it's just more difficult, much more difficult, if you use a drug while possessing a security clearance. So some of the just general forms of mitigation that we'll use very often, the individual went to treatment. So if you go to rehab, or there's even online courses, there's different things that we have people do to help us build out their case. But that's a way to mitigate. So if you have gone through treatment, that's good mitigation. But if you're going through treatment repeatedly and you're relapsing, and the drug is cocaine or methamphetamines or heroin or something like that, then you're stacking the deck against yourself. So the relapse is an issue because they want to know that you went through treatment, you successfully completed the treatment, and you haven't used it since. If you went through treatment and then you went back to using it, you're not following the directions of the treating professionals, you didn't comply with your treatment, you clearly have a bigger problem than you would have had you been able to just go through treatment and not use the drug again in the future. So it's going to be a little tougher. Not impossible, but a little tougher to establish the clearance. Have you disassociated yourself from the individuals that you use drugs with? That's the growing out of it argument. A lot of people in college hang out with other college students and do drugs. Maybe not heavy drugs, maybe it's just, like I said earlier, Adderall to study for exams. Maybe it's marijuana edibles because you're right next to a dispensary in the state that you're in. Those things are not all that difficult to mitigate, but you want to show that you're not hanging around with drug addicts and drug dealers. You graduated, you got away from the people that you did those things with. It probably wasn't you that was promoting those things. You weren't selling the drugs, you weren't distributing the drugs. You no longer hang out with the people that you did, THC edibles with or whatever it was. So, that's a good type of mitigation. I talked a little bit about the treatment and the training, and you should have an attempt to not relapse because a relapse can be a problem for you. Another thing we do is we have you get an evaluation. Can you go and meet with a professional, go and meet with an expert and have them do a thorough evaluation, and they're going to tell me and Ryan what they think. Do you have a drug use problem? Do you have a drug abuse issue? Is it in remission, or is there no issue at all? We're going to use that expert evaluation to be able to help mitigate the concerns as well, hopefully. Hopefully it's favorable. Talk through the marijuana as legal. This is a hot topic. We deal with it all the time, especially for people who just don't contemplate applying for a security clearance at any point. Maybe you were going through college thinking you were going to be an engineer, and then all of a sudden your engineering degree that pays the most, or your engineering job that you want that pays the most, is for Moog, is a contractor that contracts with Moog or contracts with the Air Force or something. And now, surprise, you need a security clearance that you would never have needed otherwise. And if you can't get that security clearance, maybe you're going to make $30,000 or $40,000 less a year, maybe more. So, it's not all that uncommon now for us to deal with people who have used marijuana in college, and we're generally able to mitigate it. But again, it's not a decision that's made in a vacuum. It's not going to be, you overcame the marijuana issue, you get a clearance. There's all the other factors that come into the whole person concept. So this is just part of it. And then this is a question we get a lot. Well, am I going to get caught because I went to a dispensary and I had to give my information, or I have a medical marijuana card, I'm on lists, am I going to get caught? Not yet. Is the answer that I give everybody. Not yet. As far as I know, they're not cross-referencing those records yet, but it wouldn't shock me if the federal government decided they were going to put some money behind cross-referencing those records at some point. It wouldn't shock me at all. I don't think they're doing it yet, but just like they're starting to monitor your social media, just like they're getting into emails, we're litigating cases now where we're looking and, how did the federal government even get this information? But they're getting the information now. So under continuous evaluation, you are now putting yourself in a position where you're constantly being monitored. And if you're putting your name on a list of people who went to pick up drugs, then there's a decent chance at some point in the future you're going to have to answer for that. You can get rid of your medical marijuana card now, and you can say, I'm not going to use marijuana anymore, but you got to go one step further. Instead, I'm going to do this, and this is working really well for me. And if you can convince them that they don't have a reason to think that you're going to go back to using marijuana to treat anxiety or whatever it is that you were dealing with, then you have a really good chance of mitigating that concern. All right, Ryan, and I will shut up because I'm sure you got some stuff to say here.
Yeah, you covered a lot. The only thing I want to say is, obviously you heard Tony indicate the importance of, just being honest, whether regardless of whatever your drug use is. You referenced obviously that, there's a chance that if you don't disclose it, that, they won't ever find out and you'll be good to go for the rest of your career. However, I can't tell you how many times I have seen somebody not disclose that information, and then later on, I've even had it 20 years later, where an individual didn't disclose it previously, and then somehow it popped up, whether they had an epiphany and decided to disclose it, whether one of their friends that they put on their SF-86 indicated, oh yeah, I smoked marijuana with that guy about 10 years ago. Something along those lines, that they find out about it one way or another, and eventually that leads to not only the guideline H, which is the drug involvement issue, but also the guideline E, which is personal conduct. And as Tony mentioned before, if you disclose it, it's typically easier to mitigate the guideline H as opposed to guideline E, because guideline E looks all encompassing and it looks to literally the characteristics that they look for in, an individual who should hold the clearance. And if you lie, that's something that obviously is contrary to that. The only other thing I'll mention is that sometimes you'll hear a reference to something called a bond amendment. The bond amendment essentially provides guidance for either prohibition or disqualification for certain types of clearances. The only prohibition for a clearance is if somebody is an addict, and an addict is specifically described as any individual who habitually uses any narcotic drug as to endanger the public morals, health, safety, and welfare. I have only heard of this happening on one occasion, and this was actually something that was brought to the attention of us by the director of DOHA, Defense Office of Hearings and Appeals. And essentially somebody testified, and they were actually under the influence of a drug at that point, and they also testified that they would continue using it. So the judge in that case determined that that individual was a habitual user and met the definition of an addict. Very, very rare, doesn't typically happen. Even if you testify that you have an intent to use it again, if it's illegalized, probably not the best strategy. But that's not going to be the definition of an addict. It's going to be somebody who, kind of meets those guidelines. So that's really the only situation where there's what they call a prohibition for clearances. Everything else, and honestly, even in that circumstance, I probably could have made a pretty good argument as far as why the guy should have had a clearance. But those are the main aspects that are important to consider as well.
All right, Ryan, you want to walk us through guideline K?
Yeah, let's do it. So guideline K, obviously the main thing is handling protected information. This doesn't necessarily always have to be classified information. Most of the time it is, but it could also be sensitive information, as you see on the slide there. The sensitive information could be, PII, it could be, something along those lines. It could even be, proprietary information, financial information from like a company you work for, something along those lines. So all those things can fall under this particular guideline. But most of the time, guideline K is, the handling of classified material. You see on the slide, one of the main things that their concern is the deliberate or the negligent mishandling of protected or sensitive information. So that is an important aspect to consider. Obviously, the recent example that we have here is, the Air National Guard, Army Reserve National Guard, I believe, soldier, and he, deliberately disclosed classified information while he was playing a video game on a video game. I think it was a forum. Something like that obviously is deliberate, and something like that, is not only a major concern for holding a security clearance, but also can, as you've seen, can potentially lead to some, criminal aspects. There's also an aspect to that as well, for reporting requirements, right? So a lot of times, let's use this example of the soldier, with the video game forum. If there's another individual that held a clearance and received this information, they actually do themselves have a reporting requirement to report that issue. Now, obviously, that's I don't think that happened in this case, but something like that where there's any potential or any actual mishandling of classified material is a reportable aspect, and if you yourself don't report that, that could also raise some red flags. But going back to the actual mishandling of classified information, obviously that's paramount, right? One of the main aspects of holding a security clearance is to safeguard that classified material. And if you aren't doing that, mishandling, the classified material, that's going to raise guideline K concerns. And I mentioned before, it's the deliberate and negligent aspect of it. So it doesn't necessarily have to be intentional, but if it's something that was, so negligent that, you should have known, a lot of times that's like a pattern, right? So like if you're in a skiff or something and, you're the last one to leave, and you don't close the door, right? That's a mistake. not necessarily, it may raise some red flags, but if you do it continuously, that kind of gets to that area of, negligent. You're not really doing what you can in order to safeguard classified material. So obviously, I think it's goes without saying that is a main concern. Not only disclosure of protected information, also collecting or storing classified material in an unauthorized location could also raise some red flags. If you're loading or modifying or transmitting any classified material in either a non-classified system or unauthorized equipment, also can raise a concern. If you try to obtain classified information, or if you try to review classified information that you do not have a clearance to, or you do not need to do, or you have not been authorized to do, then that also could raise some red flags. Another one that I've seen in the past, not necessarily as recent, is transferring or carrying classified information, right? A lot of times you have to have, if you're a courier and you are, transporting classified information from one place to another, you typically have to have clearance and, authorization in order to do that. If you accidentally take classified documents home, that could also raise a red flag. And if you take those classified documents home, but you try to destroy them, and it's not within accordance of the proper, discard procedures, then that's something that is also going to raise a red flag. Now, those are a lot of the disqualifying conditions. Now, going to the mitigating conditions, as I mentioned before, if it's infrequent, right? If you only did it one time, it was a mistake. Again, that could raise a red flag, but that also is a mitigating condition. It doesn't show a pattern of behavior, so that's something that is going to, provide that mitigation there. Also, the behavior was corrected. That could be in the form of immediately notifying the security officer, your supervisor, of any issue with or mishandling of classified material, and then subsequently after that, you took some remedial security training or something along those lines in order to what I typically refer to as bolstering your knowledge of the proper ways to handle classified material. I mentioned before, there's no pattern. That's also something the promptly reported. And then another big thing that they look at, this kind of goes hand in hand with a lot of the mitigation that I was talking about, is that there's no evidence of a compromise. So even if you did mishandle the classified information, and it, on one occasion was negligent, there's mitigation that looks in your favor if there was no compromise of that classified information. If there was a compromise, meaning that it got out, somebody who shouldn't have seen it saw it, what have you. In the case of, in this case, the soldier in the video games that we were talking about earlier, those are obviously things that does cause a compromise and, doesn't provide, mitigation for this. So that's kind of the main gist for the handling of protected information. Like I said, it doesn't have to be classified. It can be sensitive, but most of the time what we see is the classified material as the main issue. Which again is obviously paramount for somebody who holds a security clearance. So those are kind of the main aspects for Guideline K. I'm sure, Tony, you have maybe a couple more things to add while we wrap up here.
No, nicely done. I got nothing to add to that one. All right, what we're going to do here now, we're going to jump to some of the questions that we got. We were able to compile a few of them and plug them in here in the slideshow just so we could talk through them. I don't have all of the questions in here, and I'll get it right out here at the start. I was surprised. There were quite a few Guideline I questions, psychological conditions. There were so many questions about Guideline I that I think we're going to here in the very near future spin up a Guideline I webinar. So you guys will see us again soon. Keep an eye on your emails and social media. We'll be sending out an invite for that here soon. But we'll do, because Ryan and I can talk for an hour about Guideline I and the different types of cases and conditions. We've litigated everything, PTSD, even autism cases, different types of bipolar. There's a lot of stuff out there. None of those things are a bar from getting a security clearance, but most of those things will lead to litigation. So we'll spin up another webinar here soon and dig into the details on that and provide as much information. So please join us again soon. But we'll go through, I think, the student loans and credit reports. I think Ryan covered those. He talked about, there were some questions about student loans and credit reports being an issue. Credit report is less of an issue than people think. They know that the credit issues are there. They know that you have a debt. They don't really care if it's still on a credit report or not. What did you do about the debt? Did you resolve the debt? Are you acting responsibly given the circumstances, or are you just saying, I'm not paying that? They didn't catch it fast enough or get a judgment fast enough, so I'm not going to pay it. The federal government wants to know that you're paying your debts, so and following the rules. So that when we hit filing taxes, we hit that as well, but there was a question about how do I answer an SF-86, and this is actually the second time. So I saw the question on the spreadsheet that we got today from all the registrations, and then I actually answered this question for somebody a few days ago on a different case, a different individual. So I don't make enough money to have to file taxes. Do I have to answer yes to whether I've not filed my tax? I can't remember the exact language. Have you missed filing or something along those lines? You haven't missed anything. If you're not required to file taxes, you haven't missed anything. So you haven't done anything wrong. What the federal government wants to know is, are you following the rules? And Ryan talked a little bit about following the rules. So it's not just money for Guideline F, it's are you following the rules as well? And if you were not required to file taxes and you followed that rule, then you're fine. You don't have to disclose anything negative. You don't have to say yes to that question because you never failed to file taxes that you were actually required to file. And as long as that's the case, then you're not on the hook for anything. You wouldn't have anything to worry about there.
Just to piggyback that just real quick, Tony, there's also something that I see consistently because we do a lot with military members and things like that is a combat zone exemption. So, if you're serving in a combat zone, there's typically, this is for federal, not necessarily for state, but there's typically a certain period of time that you have to file. I believe it's 180 days when you return back from whenever you're in that combat zone. So even though at that point you're required to pay and file your taxes, you do get a little bit of an extension on that point. So same kind of situation, you wouldn't necessarily have to report that as long as you're complying with that exemption. Obviously, that's something you want to talk to your tax professional about, but that's something that I have seen and I've argued in the past that's been successful, for individuals that are in a combat zone.
Yeah, and something else to consider too is if your argument to the investigator or on the SF-86 is that I didn't file taxes because I didn't make enough money to file taxes, then you should expect a follow-up question. How did you pay your bills? Because nobody takes your word for anything in this process. And if you're saying if you worked off the books or you did something where you had the income and that's how you paid your bills, but you're not disclosing that information, you're just claiming that you lived on $10,000 in 2022. They're going to think that you're being dishonest with them. So make sure that you anticipate that question and you have an answer for that question, because there will be a follow-on question if you say that you didn't make enough money to file. Maybe your spouse was the one that was paying the bills. Maybe you're still at home and your parents are paying the bills and you're in college. Any of those things could apply. So just be prepared to talk through that, because there will be a follow-on question about how you paid your bills. So, and then also don't forget that an extension, if you have an approved extension on filing your taxes, you're not doing anything wrong. You're following the rules. As long as you applied for the extension and you filed by the extension deadline, that's not reportable either. What's reportable is a breach, some kind of rule that you didn't follow. That's what they're looking for. All right, next one there. The question just came through, I think, as Guideline H in the civilian context or something. So we'll talk about this. Guideline H is the drug use. We hit on it quite a bit, but one thing we didn't really touch on much that I think might help answer the question, if this is the question, say you're a civilian and you're going to work, you're getting a security clearance. Well, if you're going to work for a contractor where you're then going to be supporting an agency, the agency might require the security clearance. And if that's the case and you have drug use, then that agency is not going to want you on their job. And you're not going to be able to get a security clearance unless you can mitigate those concerns and get the clearance. But then another thing you look at, and there's a lot of confusion around this, sometimes you look at a security clearance, sometimes you're looking at suitability. Those are different decisions. Those are, you got your security clearance and then you've got your employment decision, which might be fitness or suitability. They'll use different terms interchangeably. If you disclose drug use, you might get the clearance, but the agency might think that you're unsuitable or unfit for the position, and you don't get a response to a statement of reasons. You don't get an opportunity to have a hearing most of the time if it's a suitability or fitness issue. Sometimes you do, but most of the time you don't. So if you are just told, well, you were found unsuitable or unfit, if it's unsuitable, a lot of times they'll give you 30 days to do a written response. That's not a security clearance. That's an employment decision. If you get told you're not getting your security clearance because you've got a history of drug use, then you get an opportunity to respond to the statement of reasons. We can take it to a hearing as well. So there's more due process protections built in there. So I hope that answers the question. If not, make sure that you follow up, and we'll be happy to answer that question for you if that didn't answer your question. Same thing, subcontracting from a prime. This was more a general question. How do I subcontract? How do I get a clearance? Well, your prime is your sponsor. They're holding the security clearance. If you're trying to get, as a subcontractor, not as an individual, but as a business, you're trying to get a facilities clearance so that you can do subcontracting work for primes on cleared contracts or cleared work, then you would need that facilities clearance. You need your key personnel in place, and you need to be able to get a security clearance yourself. So there's a lot more information there that I can give you, or that Ryan can give you, but you need to know that you need to individually, if you're going to be one of the key personnel, security officer, whatever, there's multiple people involved. If you're going to be one of the key personnel, you need to be able to get a clearance. Then your company is going to have to get a facilities clearance, but your company can be sponsored by somebody with a facilities clearance. So if you're trying to get onto a government contract, that government agency can sponsor you to get your facilities clearance. And then under your facilities clearance, you can then get your employees' individual clearances. So again, a lot more information to be discussed there, but that's generally how it works. Let's see, we talked about the immediate family members and relationships with foreign nationals. One thing we didn't talk about that we get asked about a lot is, if I disclose my mother, who's a foreign national and is undocumented and she's living here technically illegally, if I disclose her, what's going to happen? We don't know. We really don't know. I mean, will someone go and knock at her door and try to apprehend her? Maybe. It's unlikely, but it's possible. So, we're always careful about the way that we answer that question. There's a slim chance that someone's going to go and try to round up the people that you put on your security clearance application, but it's not out of the realm of possibility. So know that if you're going to start disclosing family members and foreign nationals that are undocumented here in the United States, there's a possibility that giving their location and their information to somebody could result in somebody going to their home and trying to find them. Loss of jurisdiction. So Ryan, jump in at any point on any of these if you want to, but loss of jurisdiction is very simple once you understand how they work. So a loss of jurisdiction is someone who had a security clearance and lost their sponsor in the middle of an open investigation. That's it. So either you quit because someone told you it would be a good idea to resign because you're being investigated, and if you hurry up and resign, they won't finish their investigation, you'll be all right. Well, you just shot yourself in the foot. Because if you resigned, now you lost your sponsor in the middle of an open investigation, you're flagged in the system. The only way that you can get that process started back up is to find a new sponsor who knows that you're flagged in the system, and it's going to be difficult. And they're willing to submit a CSR, a customer service request, to have your investigation completed, to then determine whether you can even get a security clearance, because it's all up in the air and you're flagged in the system. So what happens is you get the new sponsor, then maybe the new sponsor can submit the CSR, then the investigation is completed, and maybe at the end of the investigation, they say, nope, you are a guideline B and C violation, no clearance for you. So now that sponsor just wasted all of that time and energy on trying to get you through the process, which is why sponsors are reluctant to pick up people with a loss of jurisdiction. So the way you avoid loss, yeah, go ahead.
I would say, there's just one small thing too. A lot of times you see it's, as Tony said, a loss of jurisdiction happens if you lose your sponsorship during the adjudication or investigation of the clearance, right? That could be after you submit an SF-86. That could be if there's an incident report that was submitted on your DISS, Defense Information System for Security, or if you've got a statement of reasons or even pending a hearing. Any of those during the adjudicative process, if you lose your sponsorship during that time, that causes a loss of jurisdiction. Now, if there's an incident report there, and as Tony was referencing, a way to get out of that is to get another sponsor, and then they could sometimes, most of the time, pick up sponsorship of your clearance and then start the investigation over from where they left off. Sometimes they have you fill out a new SF-86. But before you do that, if that incident report contains information that is false or incorrect, and you have proof, you can't just say, yeah, it's false and incorrect. You have to have solid proof. Then you can submit an amendment request to usually it's DCSA in order to amend or remove that incident report. Very rare that happens, but if you do have that solid proof, it's an avenue you can go down, even if you don't have a sponsor. But as Tony said, the best way to actually resolve a loss of jurisdiction in the most common way is to just get a new sponsor for your clearance.
Yeah, and that challenge to the incident report, it's got to be factual inaccuracies. So your opinion being different from the opinion that's expressed in the incident report isn't going to be enough. There has to be a factual inaccuracy in that incident report, and if there is a factual inaccuracy in that incident report, then it can be appealed and the incident report can be amended.
As long as you have that solid proof, though. You
Yep.
got to have actual solid proof. Otherwise, they're going to reject it, even if it's legitimately true.
All right,
I'll take the next one real quick, Tony. Just because I know we got to wrap it up a little bit. I think you already touched on the under and over reporting of foreign contacts. As far as how to get your clearance back, same thing. You always need a sponsor. You can't get a clearance without a sponsor. If you have got your clearance revoked in the past, you need to try and get a new one for a potential job or something along those lines, you need to get that sponsor in order to get that clearance. A lot of times if you do get that sponsor, then you'll have to reapply for that clearance. And typically what we usually do on our end is we submit something called a reapplication brief, which essentially mitigates the concerns that were not previously mitigated and then caused your clearance to be revoked in the past. So long story short, bottom line is that you always need a clearance. You always need a sponsor. You cannot get a security clearance without a sponsor.
The one caveat there is that if you leave an employer on good terms, you're just leaving. Maybe your contract's up or you got out of the military or something like that. You do have a short period of time to get a new sponsor. And a lot of times they'll offer reciprocity and they'll bring your clearance over to the new agency. It's less common now, and they shut the clearance down quicker than they used to, but there's a time period there where you might be able to get reciprocity. And then there's a question about polygraph bleed over. So if I'm applying for a job at the FBI and I fail my polygraph, and is that going to affect my ability to get a clearance at Department of Defense? That's the question that was posed, basically. So, a couple things to consider there. It depends on what you disclosed, right? So, a lot of people think they just failed the polygraph and that's why they didn't get a security clearance. Maybe you passed the polygraph, but the information that you disclosed in passing the polygraph is the issue. So, if the information that you disclosed is the problem, then there's a good chance that you're not going to be able to get a security clearance elsewhere. If you failed the polygraph, then there's a decent chance you can get a security clearance elsewhere. Different agents, not all the agencies, but many agencies like FBI, for example, they do their own adjudications. Just because the FBI doesn't give you a job, I would love to know what the number is. I don't know what it is, but the FBI, they don't give a lot of people jobs, right? So, there's a lot that goes on in the polygraphs for some of these agencies, and there's unfortunately nothing that we can do about it. If you don't pass that polygraph, that doesn't mean that you're not going to be able to get a clearance or get in at another agency. But depending on what happened at that polygraph, it could limit your potential to get a job or a clearance in the future. Anything to add to that, Ryan?
No, there's two more questions that we got in the chat. I could just touch on those real quick before we wrap up.
Yep.
One of them was if I get married and my wife is a dual citizen, excuse me, if I get married and my wife has dual citizenship and I do not, will that impact the security clearance? This is kind of a lawyer answer, but it depends. It depends. It depends on communication with any foreign nationals, right? So if she is a dual citizen, that in and of itself, most likely not. But if she has family members in a foreign country that she routinely communicates with, it doesn't necessarily even have to be your communication. It could just be hers. Then that potentially could have an impact. But all those mitigating conditions that Tony was talking about previously when he was going over guidelines B and C, that all would apply. So long story short, dual citizenship in and of itself, most likely not. But if there's some other issues there as far as like foreign contacts and things, then that could potentially raise some red flags.
Yeah, and that two-part question that we talked about, the closer continuing contact and a bond of some type, that's you or your cohabitant, basically. So it's in the question, they'll ask about a spouse or a cohabitant. So the question, really talks about dual citizenship. The dual citizenship, in my opinion, is less of an issue than the foreign contacts related to that dual citizenship. You're going to have to disclose your spouse's, because she's your cohabitant, your spouse, you're going to have to disclose her foreign contacts as well, and that might actually be the more difficult thing to overcome.
Yeah, the last question here is if my partner has significant debt and we get married, will that be an issue? Most likely not, as long as that debt is not delinquent. If that debt is delinquent, even then probably not, unless you assume that debt, right? So like if, for instance, you get married and then you decide to I don't know, help her out and you co-sign on the debt or something along those lines, and then that potentially could have an issue. But as if you're not the one that actually holds the debt, and you're obviously your spouse is not obtaining that debt in some sort of illegal means, then it really shouldn't have an impact. I think those are all the questions.
Yeah. I agree. I mean, I don't even know that your spouse's debt would come up unless, as Ryan said, there were delinquent debts or something maybe tied to the address or something like that. But there isn't a spot on an SF-86 to ask you about your spouse's debts. They're looking at you. Are you paying your bills? Is your credit in good standing? Again, not so much worried about the credit report and what's specifically listed on it, but what are you doing to be responsible given the circumstances that you're in? Are you living within your means? So I know we went quite a bit over here. Usually we go about an hour, but we're at about an hour and 20 minutes. But that's great. I hope that everybody took a little something away from this. I'm looking at the number of participants here, and it didn't change. So I was wondering if people are going to start dropping off once we hit an hour. We got about the same amount of people on right now that we did back then. So I'm glad you all hung in with us, and thank you for joining us today. We will again spin up a Guideline I webinar here soon. Our colleague Dan Meyer is working on another webinar as we speak, so he should be doing one here soon as well. And the invites come through the same way. Ryan and I work with Dan here at Tully Rinckey and some of our other attorneys. So keep an eye open for that, and hopefully you can join us again in the future. But we appreciate you guys jumping on. Taylor, did you have anything that you wanted to discuss with anybody?
Oh, I'm just going to thank everyone for joining tonight's presentation, and thank you both for presenting. This presentation was recorded and a copy will be sent to all attendees in the next coming days, so be on the lookout for that. I hope everyone has a good night.
Thanks, Taylor.